This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a fairly debatable action by an insurer which was reasonable and arguable reason to deny a claim and is therefore not an act of bad faith. William A. Lemons, Jr., M.D., a doctor who specialized in obstetrics and gynecology, sued Principal Life Insurance Company for breach of contract and bad faith for its refusal to pay him disability benefits under a, quote, regular occupation rider provision contained in his insurance policy with the company. A jury returned a verdict in favor of Lemon on the breach of contract claim and in favor of Principal on the bad faith claim. In William Lemons versus Principal Life Insurance Company, the United States Court of Appeal for the 11th Circuit on April 5, 2024, resolved the disputes between the insurer and Dr. Lemons. Lemons decided to open his own OBGYN practice, which he called Covenant Gynecology and Wellness, PC. In October of 2015, during Covenant's business development phase, Lemons worked for Blue Cross Blue Shield as an insurance claims consultant. A few months later, in February of 2016, he began working at the Birmingham Metro Treatment Center, an opioid addiction treatment and recovery facility. A month later, he started working at the Fritz Clinic, another opioid treatment center. In April of 2016, Lemons opened Covenant and started seeing patients. He did not deliver babies or otherwise engage in obstetrics, and he did not submit any insurance claims for any obstetrics-related work. Eventually, Lemons devoted most of his time and resources to Covenant, and he reduced the number of hours at his other jobs to concentrate more on his OBGYN practice. Lemons' solo medical practice was unsuccessful. On July 15, 2016, he closed Covenant because he was not seeing enough patients. Lemons' deteriorating health also played a significant role in his decision to close Covenant. Beginning in 2013, Lemons started developing hand tremors and was officially diagnosed with a neurological condition in March of 2016. In November 2016, Lemons completed a disability claim form and reported that as of July 15, 2016, he was totally disabled and could no longer work as an OBGYN. Lemons was interviewed and stated that he worked at Blue Cross Blue Shield approximately 15 hours a week, at Birmingham Metro approximately 12 to 18 hours a week, and at Fritz Clinic 4 hours a week. He maintained that at the time of his disability, his regular occupation was OBGYN, and therefore Principal should approve his claim under the regular occupation rider. The claims person responded that because Lemons was working other than OBGYN jobs when he became disabled, Principal could not just look at his occupation as an OBGYN and would need to consider his other jobs in evaluating his claim. Principal eventually approved Lemons' claim under a loss of earnings provision in the policy based on the reduction to Lemons' income as a result of his disability. A few weeks later, on February 9, 2017, Principal denied Lemons' claim for benefits under the regular occupation rider provision because his regular occupation was not OBGYN, according to its investigation. Principal explained that because Lemons regularly worked at Blue Cross, Birmingham Metro, and Fritz Clinic prior to the onset of his disability, he was not totally disabled from all occupations that he was engaged in prior to disability as the regular occupation writer required. The 11th Circuit noted that the Supreme Court of Alabama has made clear that mental anguish damages are unavailable for breach of contract claims related to long-term disability insurance policies. Therefore, the 11th Circuit affirmed the district court's ruling as to Lemon's recoverable damages. The benefit update rider claim involved Lemon, who acknowledged that he did not specifically plead a separate claim related to the benefit update rider provision, and since it was undisputed that principal sent letters to Lemons regarding that rider in 2004, 2007, 2010, the letter explained that his benefits had increased to $10,000 a month, and the subsequent letters informed him that his benefits had been capped at that amount. Then, considering the bad faith case, the 11th Circuit concluded that the district court did not err in denying Lemon's motion. At trial, Lemon testified that he spent most of his time working at Covenant prior to the onset of his disability. He admitted that he did not derive any income from his practice at Covenant and did not submit any insurance claims for OBGYN services to patients. Lemon's benefits pursuant to the regular occupation rider policy provision, because the evidence showed that principal gathered facts as part of its decisional-making process, information that suggested that Lemon's regular occupation was not as an OBGYN. The verdict in the case was not against the clear weight of evidence, given the genuine issue of fact as to whether a breach of contract occurred. The 11th Circuit affirmed the district court's judgment. In my opinion, lawyers representing people whose claims were rejected in whole or in part will always include a cause of action for the tort of bad faith and seek exemplary as well as tort damages. However, if, as in this case, the insurer honors the claim that was available to the insured after a thorough investigation and refused to provide benefits related to his specialty of OBGYN because he tried but never acted as an OBGYN and admitted he made no money from the failed practice, they paid what they owed, and there was neither a genuine dispute about the coverage nor were the actions of the insurer fairly debatable. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,750 blog postings. Please tell your friends and colleagues about the blog and the videos so that they too can subscribe. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.